Everyone. Good morning, good afternoon, good evening, everyone. Thanks for joining us today. My name is Ikechukwu Uzoma, and I'll be your moderator for today. This is the third webinar in our Civic Space series, and we are grateful for your participation and your engagement during and after the webinars. We are pleased to have a long list of experts to engage on the topic of implementation of decisions from regional and human rights mechanisms around civic space, media rights, and in the context of online shutdowns. And we are also glad to have experts that will provide regional perspectives and global perspectives, as well as speak to ECOWAS specific implementation experience and procedure. So we are grateful to have you all here, and we'll get started right away. As in the previous webinars, please, you would find a globe icon towards the lower right side of your screen for you to select the language you would prefer to follow the conversation in. And for your questions and comments, please use the Q&A function still on the lower mid section of your screen. If you have any issues whatsoever, please reach out through the same function, and people will be on hand to help. We are pleased to get started today with a discussion on post-litigation advocacy and how to maximize a favorable decision. We are honored to have Deya, the Chief Executive Officer of the Pan-African Lawyers Union, to lead the conversation. You would find Don's full bio in the chat. Don, thank you for joining us. The floor is yours.
Thank you very much, Ikechukwu. And I must start by apologizing to colleagues. I'm in the middle of transit, so I'm in a place that doesn't have very good internet. I hope it agrees to let us conclude without problems. I often say to colleagues when we're dealing with human rights activism generally, and especially when we're using strategic litigation as one of the tools for the promotion and protection of human and people's rights, that the first thing to look at is that litigation is not an end in itself. In terms of promoting and protecting human rights, it should be used alongside other strategies: advocacy, documentation, capacity building, and so on, so that litigation is just one of the tools. I also often say that cases don't file themselves. Cases have to be filed. Sometimes people blame courts, national courts, regional courts, international courts, when the issue is that a case has not been filed. So it's upon us to file cases. Not only is it true that cases don't file themselves, it's also true that good cases don't just file themselves. We must file good cases in the beginning, from the outset. So we must constantly be improving our capacity, improving our knowledge, improving our litigation strategies, talking to other colleagues, partnering with others, so that we are able to use strategic litigation well. The third thing I will say is that decisions do not implement themselves. Litigants have to ensure implementation of decisions. So many times when we get good judgments out of regional courts and tribunals, like the ECOWAS Community Court of Justice, the East African Court of Justice, the African Commission on Human and People's Rights, the African Court on Human and People's Rights, it's almost as though people think the decision will implement itself just because it has been issued. So we need to strategize on implementation elements right from the outset when we're thinking of filing the case. When we're thinking of filing the case, we need to think what kind of orders will we ask the court to give us if successful? And then we think about that even as we're litigating. All litigation, national litigation, international litigation can be prolonged. So we shouldn't think in very short timeframes, 1 year, 2 years, 3 years. Hope for the best, but prepare for the worst, and prepare to dig in for the long haul. One thing that can help when you're thinking from the long haul, with the long haul in mind, right from the beginning of the cases, are there any provisional measures that you'd want to apply for? Are there any interim orders that you'd like to apply for? If so, then even as you file the case, you think at which appropriate time do you make an application within the case for any interim orders, any provisional measures, any temporary measures. Let's think creatively about this. Because in a sense, then you can force some level of implementation, even as the case goes on, and you can be continuously reporting to the court on what the respondent, usually a government, is doing. So if you're strategizing from the outset, one of the things that you must think about with strategic litigation is to have a communications and media strategy. Have a strategy for how you'll involve the media, the print media, the electronic media, the digital media, and lately even social media, so that using media houses doesn't become an afterthought, that after you file is when you think, oh, let me tell the journalists I've filed. But hopefully from the very beginning, you include colleagues from the media as you're thinking through the case, conceptualizing it at the point of filing, and every single juncture in the case, the pretrial conference, the filing of evidence, the closure of evidence, the preparation for oral proceedings, if oral proceedings are allowed, that you really include the media. One of the good things that has happened now is after COVID, many courts have learned to go online. So many courts therefore stream proceedings on YouTube, on Zoom, on Microsoft Teams, and so on. So this enables you to involve many people in the case so that when it comes to implementation, there's a huge group of people who are pushing the government to implement. Next, strictly in terms of implementation, look at the treaty establishing the court, the rules of the court, and the procedures of the court to see what assistance they can give with implementation. If you take, for instance, the African Court on Human and People's Rights, the treaty establishing it, that is the protocol establishing the court, requires that the court should report to the policy organs of the African Union on an annual basis on its activities, and including on the state of implementation of its decisions. So then you can engage the court on how your decision that it gave you has been implemented. If you look at the 2020 rules, the new rules of the African Court that were passed last year, they now provide for implementation hearings. So after the judgment, after the orders, the court can ask both the state and the litigants and other actors to give it information on the state of implementation of a decision. And then it can even hold a hearing for that. So we can use that. ECOWAS, the Community Court of Justice, does not yet expressly have such a procedure, but it doesn't mean that you cannot file a motion saying, here's an affidavit showing what has been implemented and what has not been implemented. Therefore, the court then exercises the right to be heard in response of the state and can therefore call for an implementation hearing. But we can also push for courts such as the ECOWAS Community Court of Justice to also update its rules to be close to the African Court's rules, which expressly call for implementation hearings. Then form coalition with other activists, other lawyers, other civil society organizations, and other actors who also have decisions that they want implemented. So that then when you're engaging the government, it is easy to engage the government with a matrix of a series of decisions that need to be implemented so that a holistic approach to implementation is adopted by the government. In this particular area where we're talking about digital rights litigation, you don't just talk to the civil society actors, but also actors in the tech space, tech policy activists, tech developers, coders, and so on. So there's a huge group of people asking for implementation. Then in terms of implementation, think through and engage the relevant governmental agency that should ensure implementation of the decision of a court. So don't just engage government generally, engage the Ministry of Justice, the Attorney General, because that's the chief lawyer of government. Sometimes you might be required to engage the Ministry of Foreign Affairs, because many international affairs, including relations with international courts, go through the ministry. But you might find, for instance, if it had called for reform of laws in this digital space, you might have to engage the ministry in charge of information and communication technologies. So engage them directly. Sometimes an order has been given and the order requires payment of compensation or payment of reparations or payment of monetary damages. Then that means you have to involve the Ministry of Finance, because these things have to go into the government budget. If it's not clearly budgeted for, when the government is making its annual budget, it will not be implemented. So it is very important that then you engage that ministry too. And that is why I say sometimes if you form a coalition with others who also want decisions implemented, then there's power in numbers. It's very important for human rights decisions to engage the national human rights institution when it exists. So from the beginning, when the judgment comes, don't assume that the national human rights institution knows. Go and formally inform them, seek a meeting. When you're engaging with other actors, think of things such as workshops where you disseminate to the public the existing decisions that have not been implemented. You call the media along, so you engage the media in the exercise so that they write about it. And then with this push, you engage all the line governmental agencies. Quite important to engage Parliament. In the end, if there were structural reforms required, like amendment of a law, it is Parliament that will amend it. If damages were paid, it is Parliament that will pass the budget. So it's very good to have a long-term relationship with the relevant parliamentary committee, the committee in charge of legal, human rights affairs, but even the committees that write up the budget and ensure that the budget is sufficient to meet all the obligations of governments. In some certain cases, you can use national follow-up litigation. So you take the judgment from the ECOWAS Community Court of Justice or the African Commission or the African Court, and you file a case with it, pushing for its implementation using your national laws. And finally, and this is the last point I'll make before we democratize the debate, is think of treaty reporting procedures. Our states are supposed to report to the African Commission on Human and People's Rights every 2 years. Citizens CSOs, or as some like to call them, complementary reports. So one of the informations that you can bring to the attention of the African Commission on Human and People's Rights, but also universal periodic review in terms of the UN, are what are the pending decisions of international courts and tribunals that have not been implemented, so that then the treaty body engages the government, and hopefully the government can also then make commitments there towards implementation, even if they implement in stages. So I think I'd like to stop here and hand over the floor back to you, Ikechukwu, in case colleagues are able to debate on some of the ideas I've put. Thank you.
Thank you so much, Don. Thank you for that enlightening intro to the conversation around implementation. And, you know, just a follow-up to the first, one of the earlier points you made around media engagement. We usually find that there is the language that, you know, everyone understands, and there's the language that lawyers speak. And so even in engagement of the media, sometimes they tend to be that disconnect in terms of, you know, clear communication. What has your experience been around, you know, preparing communication for, you know, government actors or other targets of, you know, the media engagement in a way that is effective and helps with implementation down the line?
Thank you very much, Ikechukwu. It's very good that you have highlighted and emphasized that point. Yes, it is true. We as lawyers, or those of us who are lawyers, sometimes tend to write in very lawyerly language that suits courts, language that's very stiff in terms of day-to-day communication. And sometimes this is a put-off because then other constituencies don't understand you. And that is why, for me, I think it is important in strategic litigation to have a communications and outreach strategy from the beginning, and to have a multidisciplinary team. So the lawyers will do the hard legal part, but we have other kinds of activists. We have colleagues who are communications professionals and so on, let them run the public communications part. They'll be able to design different messages for different audiences. They'll be able to prepare, for instance, draft press releases or even draft articles, which when you give a journalist, she or he can then just customize and publish. They'll be able to determine and design content that is suitable for social media, for Facebook, for Instagram, for Twitter, and so on. So for me, I think the important thing is to work as a team. And even if it is not possible to have a big team, to be very conscious that the way we communicate to courts is not necessarily the way we need to communicate to government or to other stakeholders.
Yeah, fantastic. Thank you. Thanks a lot, Don. Just one big takeaway, like go for the best, prepare for the worst, and plan to dig in for the long haul. So Don, we'll stop at this for now with you, but please hang on. We'll get to the question and answer session at the end of the webinar. But thank you so much. We'll transition now to our next speaker, who we are really happy to have. His name is Pedro Vaca, the Special Rapporteur for Freedom of Expression of the Inter-American Commission on Human Rights. You would find the Special Rapporteur's bio in the chat, and the Special Rapporteur will be speaking in Spanish, and there will be, of course, interpretation to other languages. Mr. Special Rapporteur, the floor is yours.
Muchas gracias por la invitación, en especial al RFK Human Rights por este trabajo y por convocar a la Relatoría Especial. Bueno, en esta sesión que entiendo tiene que ver con la implementación de las decisiones que se toman en cortes internacionales de derechos humanos, entiendo que ya de alguna manera se ha abordado el componente del tiempo, ¿no? Que llegar a una decisión de esta naturaleza suele tomar mucho esfuerzo y mucho tiempo. Particularmente hablo del Sistema Interamericano de Protección a Derechos Humanos, donde está la Comisión y está la Corte, y donde los casos suelen tomar bastantes años. Pero yo quisiera, en primer lugar, hablar de dos lugares de la decisión, o al menos en las decisiones de la Corte Interamericana, creería que es equivalente a cómo funciona en otros sistemas internacionales de derechos humanos, y es cuando se tiene la sentencia, por ejemplo, o el informe de fondo en el caso de la Comisión. Hay dos componentes que son muy importantes: el análisis de derecho y las conclusiones, y las medidas de reparación. Digamos, para hacer incidencia o para avanzar en la implementación de los estándares.
Pour être capable d'avancer dans la mise en
expresión, que es del que se hace cargo la oficina que lidero, estos dos elementos son muy importantes. Y entonces quisiera tomar como ejemplos algunos temas en los cuales el sistema interamericano ha tomado decisiones. Entonces, por ejemplo, en el hemisferio, en el continente americano, fue o ha sido históricamente muy común que los códigos criminales, los códigos penales, incluyeran
in our hemisphere, the penal codes included
y otras tradiciones jurídicas distintas a las latinoamericanas, encontraban el uso del derecho penal incompatible con el ejercicio de la libertad de expresión cuando se refiere a asuntos de alto interés público. Entonces, tenemos varias sentencias en la Corte Interamericana.
When we speak about public interest topics, we have a number of decisions, of judgments, and there are a number of very important standards. I would say there are 5 levels of implementation. The first level would be the national level in general terms. The freedom of expression decisions have been taken in by the states. However, very often, the origin to the risk of freedom of expression repeats itself. So, a number of offenses are depenalized, for example, against the honor But maybe 10 years later, the same topic reemerges. Oh, some decisions hibernate and then they come back. Adjustments may happen. Sometimes they are executed, sometimes they're changed. So you need to think about this plan of a national debate. And then there are a number of very successful agendas in the regional level. If we think of 2 judgments and the Inter-American Committee for Human Rights, is there something going on with the English interpretation? Is there a problem?
It's fine now. It's fine. It's sorted now. It's working now.
Perfecto, vale. Bueno, comentaba que hay, si tomamos, por ejemplo, 2 sentencias en materia de acceso a la información pública, Gómez Lund y Claude Reyes, miramos 2 cosas muy especiales. La primera es que toda la región empezó a hablar de transparencia y acceso a la información pública. Es decir, antes de estas sentencias eran muy pocos los estados de la región que tenían instrumentos legales, que tenían, digamos, procesos, instituciones a cargo de la transparencia y el derecho de acceso a la información pública. Hoy en día, los que no tienen son la excepción. Casi todos tienen. Entonces es claramente identificable como, por ejemplo, en el 2006 hay una sentencia, en el año 2010 la OEA, digamos que la Organización de Estados Americanos, publica una ley modelo de acceso a la información. En el año 2010 sale Gómez Lund, que es la otra sentencia que habla sobre graves violaciones a los derechos humanos y el acceso a la información pública. Y desde el 2010 hasta el 2020, casi que todos los años, distintos estados de las Américas iban avanzando en instrumentos legales que se inspiraban en una...
Other legal instruments were created, inspired by 2 inter-American legal decisions. I would call this a practical impact, practical actions that can advance freedom of expression. The case in Colombia, a journalist that was beaten up during a demonstration that was outrageous by the military and security forces that work in demonstrations to crush demonstrations, beating up journalists writing about the demonstration. So this is a measure that can actually be evidence of the practical aspects. To put this in very concrete terms. So here we have one of the most beautiful aspects of this work. We're talking about symbolic ways. We're talking about monuments. We're talking about accountability, accepting responsibility. I don't know if we can talk about legal cases here, but yesterday the Inter-American Tribunal published the judgment of a case litigated for 10 years, and one of the reparation remedies against the Deya, a Colombian journalist who was raped, tortured, kidnapped, and one of the reparation remedies established by the court was the creation of a center for dignifying women that are victims of a sexual aggression in journalism with the support of the state so that the center can operate. So this is supposed to be a place of easy access to the victims. So symbolic reparation also has a long-term effect. And listening, when I heard Dawn, I thought, well, there is a social plan actually. And this is a place of impact that is the most difficult to obtain. In very simple terms, I would actually say that what we aspire for is that the human rights violations don't actually happen. And a lot of the safeguards and guarantees only happen when society gets to know and embrace human rights discussions. In addition, all the discussion generates empathy for those who are most vulnerable, as well as intolerance and rejection vis-a-vis these violent acts. So we have not advanced, honestly, a lot in the region. I could talk about some concrete changes, but what's important is to move ahead with these topics and think how we can actually appropriate ourselves, how to make the society aware of what's happening in international discussions on human rights, and then prevent other violations from happening. Thank you so much.
Thank you so much, Pedro. Gracias. And just to follow up on your question, on your presentation, in terms of the classes of decisions we receive or classes of reliefs that the courts or other mechanisms grant, in your experience and, both as special rapporteur and in your interaction with lawyers, what's usually the easier reliefs or the easier decisions to implement? Are they like the pecuniary or damage like decisions or reliefs, or the structural reliefs like you spoke about, setting up, an institution to highlight the impact of this classes of violence against women? Do you find that such, memorial-like reliefs that are easier for governments to implement as compared to like pecuniary or damages ordered by the courts, or even now structural decisions that suggest structural changes in litigation by legislation or by other acts of government?
Definitivamente la más difícil es la investigación y sanción de los responsables.
The most difficult is investigating and punishing the perpetrators. In general terms, the Inter-American Convention decisions, there's some kind of order. So first there's investigation, and perpetrators must be then brought to justice. So we know that it's difficult to implement, because that's why you're going to the Inter-American Tribunal, because there is impunity in a certain country in terms of the prosecution and investigation mechanisms. I would say that this would be the most difficult to implement. But obviously, in my experience, if I were to leave the place where I'm speaking from now, I think that the attitude of the states as for the implementation of decisions is the most difficult. It's not as if the symbolic are easier, or pecuniary or damages. I would actually talk more about the attitude. This is very difficult. I have seen cases where there is very little will, very little attitude favoring change. and very often not even knowing the decision. And obviously implementation will be very difficult. And there are also cases where the attitude of the state is compromised. So international litigation, the states and other stakeholders may be counterparts. So there's the idea of a conversion point to prevent these violations from being repeated. So I would say that the attitude of those who implement decisions is a very important factor.
Yeah, the attitude of the state authorities that implement decisions is an important factor. And that's like a good takeaway from this conversation. And thank you so much, Pedro. Please hang on. We would like to take a few more questions at the end of the webinar. And to take the conversation forward, we are excited to transition to our next speaker. Her name is Lydia Kembabazi, and she is an advocacy officer at the Institute for Human Rights and Development in Africa, IHRDA, which is one of the organizers of this webinar series. You would find Lydia's bio in the chat. Lydia, thanks for joining us. The floor is yours.
Thank you, Ikechukwu. Good morning, good afternoon, good evening, wherever you're listening in from. My name is Lydia Kembabazi, Winyi. I am the advocacy officer at the IHRDA in the Gambia, and we are very honored to be part of this discussion. My discussion will be specific to the ECOWAS court decision implementation. And I would like to briefly talk about what the experiences have been, the learned lessons, and what we can have as best practices that we can learn from in implementing our decisions as the ECOWAS court. So to set it off, I would like to state that while we seek to advance human rights and the rule of law aimed at national and regional policymakers and governments through litigation, our key objective, of course, for implementing decisions is based on the premise to increase respect for human rights, specifically by making the existing standards and institutions work. So the question today we have to ask ourselves is, beyond litigation, what do we need to do to make human rights a reality, specifically in this instance, civic space and internet shutdowns? Our ECOWAS court has had over various decisions on human rights issues. We know that decisions are binding. They are supposed to appoint an authority to implement decisions, but yet to what extent do these state authorities actually implement these orders? So it is critical to note that the implementation process, of course, will be diverse, since each case presents with itself unique complexities and challenges, which can always be economic, social, political, cultural, meaning one size fits all may not be able to work. However, this also goes back to what Dawn mentioned. We need to put into consideration at the time of drafting the application, at the time of inception, what do we need to see in a long way in resolving all these issues once we have a favorable decision? So looking at the customary international law rule of PACIN, all these ECOWAS member states, of course, are obliged to abide and comply with these decisions of the court in good faith. But as Pedro has also just mentioned, the issue of attitude and political will is a challenge. We can see that the lack of implementing authorities in most of our member states, which in itself proves as a challenge, especially that out of all the member states, we only have 6 to date that have appointed authorities: the Gambia, Burkina Faso, Nigeria, Ghana, which have all appointed their Minister of Justice or the Attorney General to be the authority. Guinea has the Chief Registrar of the Supreme Court, and Mali the Minister of Foreign Affairs. So a question again, if there are no procedures formally provided for litigants to follow up with these state agencies to ensure implementation with a court judgment, how then can we ensure compliance? Of course, a question for us to ponder is how to support states to set up or appoint focal point persons in these offices that will be specifically to follow up decisions, to implement them using maybe our ministries, parliament, tech companies, the media, so as not to frustrate what we intend to protect anyway. It is also important to note, however, that there's no correlation to appointing an authority and implementation. So what can we learn from these compliance success stories? Comparatively, looking at Niger, which, albeit not having an appointed authority for execution of its court's decision, it almost has a 100% compliance record. What is Niger doing that we can learn from and adopt to our own contexts? I will specifically refer to the case of Fodi Muhammad and her children, who, due to their status as slaves, the court condemned the state of Niger and ordered payment of damages as reparation for the injury suffered in this June 2021. And this was paid off last week. So what is enabling this swift compliance, even if it's not related to our civic space, but what can we comparatively be adopted in our member states to ensure that human rights is a reality and implementation of decisions is actually realized? In regards to our discussions, we all know the right to freedom of expression is a cornerstone of democracy because of its power to influence awareness, to create accountability. But as CSOs, what proactive steps can we take as initiatives to ensure that these cases do not slip through the cracks? The case of Togo, the case against Togo by ECOWAS has really blazed a trail for us to leverage our expertise, our coverage, and ensure that this does not happen again. Can we harness the power of that decision to ensure that laws, policies, not only in Togo, but in these member states are aligned to and ensuring human rights principles in regulating online content? Dawn mentioned an issue of treaty bodies reporting and all that. And we noticed that we should not wait for really a country to shut down the internet again, despite having decisions from the ECOWAS court, but also the UN, the United Nations Human Rights Council resolution recognized that intentional disruptions and shutdowns are a violation of international human rights law. So how are we as CSOs, how are we as member states taking proactive initiatives to ensure that some of these laws actually are domesticated as a decision is passed into law using our own national procedures to ensure that it does not happen as a countermeasure, not to wait for it to happen and then we go back to litigate. And still addressing the issue of visibility of these popular cases is an issue that impedes implementation. I cannot emphasize enough the point that Dawn raised on the issue of the media, but the Togo ECOWAS case should be a stepping stone for us all to account, to hold accountable our governments, especially that court has not only ruled that it's illegal, but it should not be repeated. So the importance of the media, mainstream, social media, print, academia. What are we having as discussions in our universities, our law students, researchers, to popularize the monumental decision to ensure that these landmark decisions do not slip through the cracks. It could be through the capacity buildings, translation, especially that the court's official languages are French, English, and Portuguese, and national languages at the local level. And of course, this would help us become more aware in terms of censorship, surveillance, so that the often actions that we take to enhance internet freedom and protection will benefit all of us as users or netizens, as we have come to be called. Key to note also is our capacity for effective implementation, to follow up the progress, to follow up on decisions, which fits already into what I already discussed about best practices to adopt into our own context. As CSOs in member states, we can create coalitions. The African court in itself has a coalition for an effective African court. How can we use the power in numbers to share information, to share expertise, to foster discussions about these decisions for persistent collective advocacy? Of course, on that, there's also an opportunity for us to harness progressive practices of the court. Dawn mentioned that the ECOWAS court may not expressly provide for reports coming in, but it has from June consistently been mentioning, I'll mention except just two cases, Fodi Muhammad and others versus Niger, and Kadia to Civic and others versus the state of Mali. All 2021 decisions, the court orders the states to submit a report to the court concerning the execution of the decision within 6 months of receiving notice of judgment. Can we then use those bands to follow up to ensure submission of a compliance report, for example, or engage the different state agencies and arms of government that are involved in ensuring compliance of a decision, so that at the end of the day, we have used these decisions that have given to us. We've used these opportunities to ride on progressive practices that are available to us. So as I would like to conclude, I would like to also reiterate and emphasize that much as we strive to have principles, laws, policies put in place to ensure that civic spaces are protected and the laws put in place are definitely legal, they are necessary, they are proportionate. The implementation or compliance with decisions is what gives legitimacy to our actions and to the court. How we intend to implement, of course, the decisions should be determined right at the time of case identification, case building up to litigation, about how at the end of the day and what at the end of the day we would like to achieve. I implore us to endeavor through all our active efforts to use these favorable decisions for the growth of positive jurisprudence, so as not to fail the people whose protection we sought in the first place. I thank you for listening.
Thank you so much, Lydia. That was great. That was really good, especially the lessons learned from your experience, and I know IHRDA's experience. And just to touch on, one of the points you made around, supporting or engaging with the government to support their implementation structure where it exists, or to encourage that such structure is created where it doesn't exist. Most times CSOs are in a sense always at odds with the government. And most of these cases that come for implementation are against the government. And so there's that perceived adversarial relationship between the litigants and the government. But what has been the rule of thumb in terms of maintaining the relationship with government actors, especially the designated agents of government for implementation, to ensure that there's, at least a friendly welcome, at the end of litigation when implementation now needs to start? Like, how do you balance that variable? Because sometimes if that relationship is not there, then it's impossible to even start to have the conversation. But if it's there, it helps a lot. What has your experience been?
Thank you, Ikechukwu. I'll use an experience I had, of course, coming from Uganda, regarding the issue of having to pass the anti-torture law, yet almost all the reports every year that came in were always implicating government agencies for that. So it is in power of numbers in terms of the coalition against torture that we had. Who speaks for you when you go before these government officials? If it is not an organization that clearly is in the good books, if I may call it, of the government, then it might not be easy to have audience. But also, who is helping you to reach, like, for example, a president to sign? We had to lobby then Commissioner Dupe Atoki, who was at the African Commission then, now is a judge at the ECOWAS court, to come in. Power speaks to power. She came in to speak to the National Human Rights Institution commissioners, to speak to the president about this, but also who's tabling your law in parliament. Is it the opposition party, of course? Definitely it's going to have a setback. Can you use objective members of parliament who actually understand that I might be in the ruling party, but this is actually vital for the protection and promotion of human rights? So like I mentioned at the beginning, every case presents in itself with its different complexities and challenges, but you then get to the table and form an advocacy strategy according to what challenge you might face or are facing. I hope I've answered that.
Oh yeah, you have. You have. And so and a clear mapping with an understanding of the political dynamics is important, you know, as you said, and Don also mentioned from the outset of litigation, because you want to, you know, have a broad enough coalition to support litigation before you're in court, during the litigation, and post-litigation in terms of implementation. Thank you so much for that. Please hang on. We'll have a conversation after our next speaker. Thank you so much, Lydia. To take the conversation forward, we would like to encourage the participants to please send in your questions. We received a lot of questions already, and we are saving them for the question and answer session coming after the last speaker. So please continue sending your questions in any language of your choosing, and we'll get to those questions in a bit. To take the conversation forward, we are really excited to have Professor Rachel Morey, who is the director of the Human Rights Implementation Center at the University of Bristol and professor of international human rights law. You would find Rachel's full bio in the chats. Rachel, we are glad to have you. The floor is yours. Okay, it seems, yeah, Rachel had a challenge because she's traveling equally, she had a challenge with her connection, and I'm sure she would return soon, but maybe she just dropped off a bit. But we would proceed with the conversation, especially since we have these questions, and I would like to invite Don, Lydia, and Pedro back up. Okay, I see Rachel is back. So let's just give it a moment. Fantastic, Rachel. We just introduced you, and please feel free to make your presentation. And if the connection is poor, we won't mind if you turn off your video accordingly. So thank you so much. The floor is yours.
Thank you so much. And I'm so sorry. Like Don, I'm not calling in transit, but I'm from I'm in a hotel.
Rachel, we don't hear.
Oh,
yeah, we don't hear you.
Can you hear me now?
No.
Can you hear me?
Yes. Yes.
Brilliant.
Thank you.
I'm so sorry for the disruption. I'm calling from a hotel in the Gambia, and the internet is patchy, as that just illustrated. So I'll do my best. I hope I don't get cut out. Thank you so much for inviting me to give this presentation. I'm going to draw on a large research project that we've been doing at the Human Rights Implementation Center in Bristol, in collaboration with the Open Society Justice Initiative and the University of Pretoria, as well as engaging the IHRDA and PALU as well. And what we did is we took a number of decisions from UN and regional treaty bodies, including the African Court and Commission, the Inter-American Court and Commission, the European Court and UN treaty bodies. We didn't look at any of the sub-regional courts. And we tracked to see the extent to which they'd been implemented. So if they'd ordered compensation, we had a look at whether this was paid, how long it took, if legislation had to be adopted, what was the procedure for doing so. So I'm going to outline some of the findings that are relevant to you, and then set out what I think this might mean for litigants and civil society organisations. Just to say at the outset, the comments I make are not to detract from the underpinning obligation of states to implement and to take measures to give effect to the decisions, but maybe what we found can explain some of the complexities in doing so. Firstly, there's not one single factor in each case that determined implementation. As Lydia noted, there are a variety of issues that impact on implementation, including the perception of the body issuing the decision, the visibility of the decision, the involvement of numerous actors at the national and international levels. A point that Pedro made in his presentation about decisions can hibernate, we also found this. Implementation is not linear, I think there's often a presumption that it will continue to improve over time, but it can go backwards, and compliance can be very fragile or temporary. And implementation also depends on the complexity of the reparation at stake. Some of them take a little time to be implemented, but for others it may take considerably longer. And the process of implementation can be punctuated by developments that aren't related to the ruling itself. And that gives sort of windows of opportunity, if you like, to open and close. And throughout all this are the victims, their needs and expectations. Secondly, as Don said, decisions don't implement themselves. Implementation is not automatic, even if the state authorities are willing to comply. Sometimes it's to do with lack of knowledge, the decision has not been communicated across relevant ministries or departments, and also because technical, administrative and bureaucratic procedures need to occur to implement the various reparations. So it will always require some additional procedures at the national level. A decision from international level, even a court, will not automatically result in implementation of the reparations. When you have a domestic court judgment, this will start a process that will trigger, for example, an individual to be released from detention or compensation to be paid. But that's not usually the case with decisions coming from outside of the country, whether those are from the African Court, ECOWAS Court, Commission, or the UN. These judgments are not considered usually to be self-executing. Some countries, and there are very few and far between, have national legislation or constitutional provisions which give these international decisions the necessarily national legal status to be implemented, but there are not many of them. One tactic we saw, and Don mentioned this, is to register a decision or judgment from an international body in the national courts. And there's an example of this in Zambia. Dr. Chongwei was awarded compensation, and then there was a delay in the payment of that. So Dr. Chongwei took the case to the High Court of Zambia and ordered them to direct the government to pay the sum agreed, and then on to the Supreme Court. But that's not ideal. It takes time, and it puts the focus back on the victims to prompt the implementation. There are challenges involving the independent arms of the state, the legislature and the judiciary. So if there is a requirement in the decision that legislation be amended or an investigation reopened, for example, this can raise additional challenges. Looking at legislation, the process is complex. The legislature will need to be informed of the decision. That may not happen. And in some of the cases that we looked at, legislative change occurred through the normal processes of submitting a bill by a particular ministry, for example. And once the bill reaches Parliament, it will be subject to the same deliberations by political actors who may have limited awareness of the human rights system or don't consider it as something that's deserving of importance at that particular time. And legislative amendments will also be subject to budgetary considerations, as with any other bill passing through Parliament. Other things that we found is the lines of responsibility and communication are not always clear. In a good number of the cases that we examined in African states, it wasn't apparent who should disseminate information on the decision, who should determine lines of responsibility for implementation, and who should engage with the victim. So even if there is a mechanism set up to coordinate action at the national level, something that Lydia mentioned, that information may not be passed on. Ways to engage the victim post-decision is not always clear, to the extent that sometimes the victim themselves have to initiate processes of gaining compensation, and they're not approached by a state authority to do so. And the last point I want to make in terms of findings is around specificity. There's quite a lot that's been said around making a decision specific in terms of what the state should do to implement. And that can apply in a range of contexts. And one of these is deadlines. If you look at these decisions, most of these international bodies use deadlines to indicate when the state should report back on the measures that they've taken. And often it's a single deadline, say 180 days to report back. It's not at all clear whether that is the date on which the state has to implement the decision or not. And what we have seen is that deadlines can be used a way of continuing the dialogue with the state. So the Inter-American Court sets out different deadlines for different types of reparation, and its approach facilitates an ongoing dialogue with the state post-decision. And there's been a shift towards trying to make these decisions measurable. So just to take an example from the ECOWAS court, requiring Togo to take all the necessary measures to guarantee non-occurrence of this situation in the future. Even if it's clear what the state has to do to implement, that's not easily measurable in terms of a particular time frame or who should do what. So what does this mean for litigators and civil society organizations? Firstly, when drafting the submissions, particularly if reparations have to be part of the submission at merit stage, for example, groundwork for implementation can start in the submissions of the pleadings of the case. And I think this point has been well made by Don and Lydia already. Using different deadlines in the decision, so requesting that the court or supranational body set out different deadlines by which the state will engage and have a continued dialogue with the international body can facilitate implementation. And also we noticed instances, for example, the Inter-American Court preempts in the reparations any obstacles that are likely to arise. For example, it might presume that the state will use the argument that amnesties, statutes of limitation, for example, will mean that it will not be able to implement the reparations. So that's put in the decision to make it clear that it can't use those arguments when implementing the reparations. And sometimes we saw that a particularly contentious decision can overshadow or impact on maybe less contentious aspects of the decision. So the inclusion of, if you like, low-hanging fruit, easy to implement remedies, things that can perhaps be achievable in the short term and can help open up a dialogue, may also assist in the implementation of the more tricky parts of the decision afterwards. And just finally, post-decision, and again, I think these points have been well made by others. It is useful to have pro-compliance partners, those who are allies in implementing the decision. They may not be the same organizations or individuals that would have been thought about when the case is being submitted or when it's pending, and they may not be the usual suspects. Establishing a coalition of civil society organizations who have broad interest in the judgment but may not have been interested or aware of it whilst it was pending. Friendly parliamentarians or parliamentary committees, allies in government, and so on. We saw some examples where the actions of one key individual, so in government or a senior position, for example, was extremely influential in pushing implementation forward. And finally, drawing on individuals who are formally members of that particular treaty body or court can be useful interlocutors in devising a strategy going forward for implementation. Even if it's not expressly mentioned in the recommendations or reparations of the decision, encouraging the government to adopt an action plan which identifies appropriate government ministries, timelines, and resources can also be useful. So there's loads more I could say, but I'm going to stop there. Thank you very much for your time.
Thank you. Thank you so much, Rachel. And thanks for sharing that research, which really has been reflective of the experience and from both the global and the regional and inter-regional perspective. But I just have a follow-up question, like how do you define tricky? How do you define low-hanging fruits in the context of implementation? Is it do you find that certain, and this was a similar question I asked Pedro, do you find that certain reparations are easily implemented and others are tricky, or is it relative to context?
Yeah, I think from what we found, so we did start off with the presumption that maybe payment of compensation might be easier than others, but that certainly isn't what we found. And you're right, it very much depends on context. And I think there, a detailed awareness of the complexities, the political nature, the issues which our government allies and so on at the domestic level can be really helpful in just determining what is going to be tricky and what is going to be perhaps easier. So I don't think there's a clear indication that one type of reparation is easier to implement than others. I think it very much depends on what the particular case is about, who the particular actors that are likely to be involved.
Fantastic, thank you. Thank you, Rachel. And at this point, I'd like to invite our other speakers for a few minutes of interaction. And as they all join the screen at the moment, I'd like to just reflect a bit, around the best practices that have come out of the conversation today. And it does seem like coalition, like forming or establishing coalitions at different levels is important in terms of implementation. And implementation is a critical part in the planning stage, of litigation. And so I wonder if it's more effective for these coalitions to be more domestic or more localized in a sense, as opposed to being more regional or more international. And it'll be great to get the thoughts of our panelists. Please, can we add the panelists to the screen? It'll be great to get the thoughts of the panelists. And Lydia, I could start with you. In terms of coalition building, do you find that having regional or continental coalitions for implementation would be more effective than having like national coalitions? Because from what I've heard in the conversation, it does seem like context is important, both political and otherwise. And this usually will be specific to a country or specific, to the state implementing the decisions. So where should that coalition lie? What should be the center of the coalition? Local or, more regional or international?
If you look at the issue of the ECOWAS coding itself, it's regional. It's definitely regional. It has different member states in its community. So I would really think that regional would have a lot of support, as well as a huge impact, though of course you would have implementing partners on the ground. We could have implementing partners on the ground who are able to actually follow up. For example, if I'm in the Gambia and the case where the decision came in against the Gambia, who is going to be able to actually move and have a meeting with the Ministry of Justice, for example, who's going to talk to finance with its bureaucracy of making payments and compensation, or who are our parliamentarians that are going to talk to ensure that these laws are actually domesticated into our national laws. However, if you look at the expertise that is within the ECOWAS community, it comes with a lot of potential. So it could still be regional with implementing partners on the ground as national. So as we can still leverage from partners, for example, Togo has done this. What can we now from Togo learn from that? We are looking at Niger implementing decisions despite the fact that they do not have an implementing authority. What are they doing well in their systems that doesn't seem to have a lot of bureaucracy, that doesn't seem to have issues with compliance, so that it's easy for us to learn what expertise can they lend to us, so that we are able to implement these decisions. So I think it is a multifaceted approach, but preferably, of course, with an implementing partner on the ground who is able to have these discussions with different government agencies that are able to implement these decisions. Thank you.
Thank you, Lydia. And I see Rachel was agreeing with your points. Rachel, do you have anything to add?
No, I mean, I think absolutely essentially there has to be a national coalition and allies. I think in terms of regional or external, it very much depends on the type of reparation. For example, in some of the cases that we looked at, and in some of the countries, there was a benefit of knowing that it was a decision from a UN treaty body that carried more weight, for example, and therefore the ability to engage in other mechanisms and procedures at the UN level can be particularly influential. In other contexts, the fact that it was a decision from an African body was more influential. So again, focusing your energies at that level can be particularly useful. So I think it very much depends on where the pressure points are, and again, the sort of detailed knowledge of the litigants and other civil society organizations as to what may be most influential in any particular case. Thanks.
Right, thank you. And, maybe to just get, to the extent that Pedro can give like an America or Latin American perspective to coalition building and how that works, and specifically in terms of how the Office of the Special Rapporteur also supports implementation in a sense, especially around structural reparations and as part of states' obligations, especially in your interaction with states. How have you found coalitions supporting implementation in the most effective manner?
Muchas gracias por la pregunta. A ver, la Oficina de la Relatoría Especial de la Comisión Interamericana de Derechos Humanos está...
Thank you for the question. I would say that our office exists to follow on the work of commission, and the commission in the various instances of the various cases need technical support. It's not just about supervising a judgment or a decision. I would dare to say that we are more useful in preparing the cases, actually, because that's where the office is using as a reference what's happening in other places, using technical elements and implementing decisions. Supervising judgments is usually carried out especially by the courts themselves. And then I go back to what I was saying before. If the states and the victims agree that the special rapporteur office offers support to analyze a law, a legal framework as defined by a court, this is completely within our mission. I did not have the opportunity to do this because this is my first year at this term. But this could be done very easily. The rapporteur for freedom of expression, but there are other special rapporteurs of public policies, government policies, training, civil servants, for example. This is something that my predecessor has advanced a lot in, so that we can be closer to the judiciary to share more knowledge about freedom of expression, establish bridges with public authorities and police authorities, for example.
Right. Thank you so much, Pedro. And I think we can go from the general to the more specific now. As there's a question here from Bonaventure. I think it's from Togo, and it's an interesting question. I'll read it. He says, "I'd like to know what human rights organizations in general can do so that the state of Togo can honor its commitments after being sanctioned for the internet shutdown. And he adds, what we see instead of implementation is the Togo decision being perceived as case law, and the problem of internet shutdown in countries where democracy is not well rooted. States are following the example of Togo. What should we do in this case? And I think that question is critical in terms of the fact that, for lawyers, it was a victory when the decision came through. Some other lawyers expected a bit more, but on the whole, it was good jurisprudence coming out of the court. But I can feel Bonaventure in Togo, feeling like, okay, this is a good decision, but how does it change our lives? How does it change our experience? How does it change our impact in terms of our interaction, with the civic space, with our civic space? And it will be great to, and then he asks, the last question is, what can people do to, turn the tide? I'm happy for anyone to take a stab at this. It's very specific, and it will be great to get your thoughts. Lydia, would you have any thoughts, especially since this is in the West African sub-region where IHRDA has sufficient experience? So I don't know if you have any thoughts at all.
My thoughts really would be in terms of a question, if I understood it well, asking what can Togo do and what can as the populace do and use this case, for example. For me, it would depend also on their national laws and how do they implement decisions. Of course, they are still bound by decisions of the ECOWAS court, but how do they implement them? Can we then move on from just having a decision, but can it be implemented into our national laws? Do we need to have just amendments to some of the laws that we have in relation to freedom of expression and assembly, noting that that's one of the critical rights that we have for accountability and awareness? Do we need just to amend laws for Togo? Do we need to actually create a new law for protection of internet freedom? Noticing that this is, we are all netizens, as they call us. We are connected on the internet. We can mobilize, we can assemble and have all this to ensure that we can have our rights to freedom of expression and assembly respected. So I would look at a situation where they're able to amend maybe their local laws to integrate this as part of their laws, or to actually go ahead and create a new law that then protects specifically internet freedom and protection for the users. Thank you.
Thank you. Thank you. There's another question from Ayezu Okoko. And the question is, does the losing party have any right against, the state does the losing party have any right against the garnisher, he says here, but I guess this would be the applicant, who has a favorable decision, especially regarding judgments against states and governments looking from the angle of civic rights of the citizenry regarding garnishing salary accounts. What is the ECOWAS view on this? I think this question speaks to pecuniary reparation, especially with, I guess, maybe in the context of, an employee of the community who, maybe has a case with the community in terms of the ECOWAS code. I don't know specifically, when, Ayezu talks about a garnisher and a garnishee, it does feel like it's, a case of an internal case within the community. And I'm not sure, I guess, generally with implementation of decisions, the winning party has the right in terms of enforcing the judgment, and not the other way around. And so, but in terms of garnishee proceedings, I know the ECOWAS court doesn't specifically have garnishee proceedings built into its procedure, but definitely the national courts have those procedures for enforcement of civil decisions. And so it's not really clear what the question is about, but we will just skip that for now. Apologies, Ayezu. But the other question I have is from Dunai, and the question is, I don't think strategic litigation should be seen separately from other democratic reforms in a country. What institutions do you think need more attention in this regard? And I think, there's been a conversation around this in terms of building a coalition, both outside and within government, in terms of engaging with legislators, engaging with allies in the government at all levels. And, there was that interesting point that I think Lydia made and Rachel reinforced, the fact that even in terms of, decisions from regional mechanisms or international mechanisms, working with former, commissioners or former rapporteurs or former, judges in terms of a court, of those mechanisms can be a good approach for implementation. And even, just like Lydia said, working with like a former commissioner from, I think, the African Commission, who was now at the African Court and from that country, was a good approach. So I think taking the initial step of mapping clearly who the potential allies would be is a good way to prepare for implementation. I wonder if there's something to add to that. Lydia, Rachel, yeah, please.
Yeah, actually just going back on Ayezu's question about compensation, I don't know if this is relevant. Some international bodies will set the amount, others will leave it up to the state to determine. And then there is quite a complicated process about what then subsequently happens to obtain that compensation. So one of the cases we looked at, the government was quite willing to pay the compensation, but there was no clear process by which the victim could get that money into their bank account. And that was where the international body had set the amount. And so they didn't quite have to go knocking on the doors of Treasury, but they were sort of a bit lost as to which government department they should approach just to initiate that process. And actually, at the end of the day, they needed a local lawyer to be able to get the money to be paid into that lawyer's bank account, because that was the way that the state required it to be done. So just very bureaucratic administrative challenges in obtaining money, even when the government has said that it's willing to pay. The other issue on the second question, I think there's huge and international levels in terms of engaging with other actors to try and implement these decisions. The national human rights institutions are often an overlooked body, and I think Don mentioned this specifically. They can be a very important interlocutor, even if they're not perceived to be independent. They may actually be a very useful ally in terms of engaging with government on some of these issues, facilitating workshops, encouraging the adoption of action plans and so on. And often you see that they're not used and may not even be aware of the decision itself. So I think not knowing that this information is even to what a perceived actors, I think is a good starting point. Parliamentary committees don't always know about these decisions. NHRIs don't know about these decisions. Some key civil society organizations don't know about them. So getting that information out there and visible is really important. Thanks.
Thank you. Thanks a lot, Rachel. We have time to take one more or two questions. And this one, I'll just read it. It says, I think it's from Silas. It says, I think that we could see better implementation of decisions rendered by human rights courts only if their control will move away from the political, as is the case with the Executive Council of the African Union. The control of implementation must be ensured by an autonomous mechanism and recognized as such. So I think this is just a comment, which I think I agree with it in a sense, but to the extent that it's possible that there's an autonomous mechanism outside, the Commission, the African Commission, for example, and the special procedures of the Commission. I think the coalitions, like the Coalition for the effectiveness of the African Commission and the other commission, the African Court, and the other coalition focused on the African Commission are useful platforms to engage in terms of implementation. And since they are populated by civil society organizations, they could seem as that seemingly autonomous body. But to the extent that states still have the prerogative in a sense and the power and the responsibility actually to implement these decisions, we will still need to interface with the states, and doing that in a way that's informed by other people, other lessons learned and other experiences would be the best way to go. Unfortunately, we may not be able. Let me see if we have one more question. Let me see. Yeah, so we have one more question, and we will wrap up with this. In addition to creating coordination mechanisms at the national level to implement decisions from international, regional, and sub-regional mechanisms, what other measures can and should be implemented by states or the mechanisms themselves to ensure implementation of decisions and incorporation of legal standards at the national level? And I think, particularly drawing from Dawn's comment, and Lydia, you mentioned equally, the seeming vagueness in terms of the rules of the ECOWAS Court in particular, with reference to implementation. Do we see a change in the rules of the ECOWAS Court in particular, and in other mechanisms equally, to provide better guidance on implementation as another way to go in terms of shoring up the guidance and capacity for implementation? I don't know if that was clear enough. Just in terms of rules, the rules of the court and the guidance that the court gives. Because again, there was, Rachel, you mentioned the fact that certain times the courts specifically provide deadlines and, just makes the orders specific enough for follow-ups. So on the one hand, specificity from this mechanisms would be important. But I think on the other hand, equally for litigants, maybe we will need to also review the types of reliefs we seek from the court, providing some specificity in terms of what we would like the courts to order, especially when we are aware of what makes implementation easier or what makes it difficult. I don't know if you agree with that. Yeah, Rachel.
Yeah, absolutely. I think you can use the reparation section of a decision as a tool for implementation. An excellent example I often raise is actually the IHRDA's case the DRC, the Kilwa case, where it's specifically included in the reparations that there should be a body established which should monitor implementation, composed of not only national actors, but also the African Commission itself. And so I think thinking carefully about how a decision can subsequently be implemented and how those measures can be, how those reparations can actually be measured over a period of time, can be a really useful way that the court or the commission or the committee can facilitate implementation in the long term. I also think putting a clause, and some of them have started to do this, in the reparations, requiring the state to make public the decision at the national level. So some of them say that they should publish this, they should keep it on a government website for a particular period of time, is really useful. But not only that, but publish the measures the state have taken to implement the decision. So the African Court does it in its activity reports, but actually fine state take when they do implement. And we found that there's more implementation than at first appears to be the case, but you have to dig quite deep to find it. So requiring the state to make that information public, to know what it's doing and what the processes are for implementation, can be a really useful tool, not only for that case, but also for subsequent ones.
Right. Thank you. Thank you, Rachel. Just to read a comment from the chat, and this from Deya Fabwimi. He says, I think that can happen in terms of amending the ECOWAS court rules to improve compliance. Recent judgments of the court now provide for the state to give a report within 6 months, and I think Lydia mentioned this, of the judgment as to how it has complied. We didn't have that before. So if civil society organizations can find a way to engage the court with respect to its rules, we might be able to get the amendment not only on this issue, but on other problems with the rules. Okay. Yeah, but I do agree with that position, the fact that we do need to engage the court and other mechanisms, to progressively improve the rules and the procedure and, the interaction with states in terms of compliance. I think this has been a fantastic conversation, and we are grateful to you all, Rachel, Lydia, Pedro, and to Dawn, for your insightful engagement around these issues. This conversation will not stop here. We'll continue to send questions as we get them, but we really want to thank you so much for being here and sharing your experience with all of us. Thank you so much. And to our participants, we are really grateful to you all for being through this series with us. This is the final part of the series, and we are glad to come to the end. And we are grateful to the co-organizers, Robert F. Kennedy Human Rights, the Network of Universities Legal Aid Institutions, NULAI, the Institute for Human Rights and Development in Africa, IHRDA, and the Pan-African Lawyers Union, PALU. We're thankful for the collaboration on this. And just to share that this is part of an ongoing effort by our organizations to continually build capacity in civil society and to create a bridge for inter-regional collaboration and learning around issues pertaining to civic space. And, please just remain, open to receiving further invitation for such conversations. And we would be in touch with all the participants and would continually engage you all. We would love to hear feedback as to what you would like to hear next, or what you would like for us to focus on. But we are really interested in continually building out capacity across the regions, since the manifestations of the challenges we have are similar. So I'd like to thank you all for joining, and please feel free to reach out to us for any questions or concerns. We'd also like to thank our interpreters from Communica. Thank you for the exceptional work, and thank you for keeping us strongly connected with, participants from all over the world. We had participants from about 45 countries, and it's been an amazing journey with you all. So thank you, everyone at Communica. So this will be us signing off at this moment and thanking you until we see you again. Have an exciting morning, afternoon, or evening. Bye.